Welcome viewers to today's broadcast. Today's date is August the 25th, 2024. My name remains Paul. As usual, I will title my broadcast Migrating to the US Useful Tips Part 6C. I took a little break because I was involved in other things, so I have not made any broadcast in the past 2 weeks. But I'm happy to resume, and we will continue. In my last video, part 6A and 6B, I had started dealing with the process of applying for a K1 visa, ordinarily or otherwise known as fiancé visa. And today I will continue because I had discussed in my part 6B, part 6B and A, I had talked about the very first initial steps, that is filing a petition with the Department of State and of course the USCIS. And then if the petition gets approved, it goes on to the second level, which is the visa application in the foreign country where the U.S. citizen's fiancé resides. And so that is where I'm going to start. And so if the visa, if the Form I-129 is approved, now the National Visa Center, sends that form to the U.S. Embassy or Consulate in the foreign country where the U.S. citizen's fiancé resides, because the U.S. citizen's fiancé will have to attend the interview in his home country, in that foreign country. That's where the interview is going to happen. And of course, it's going to be a K1 non-immigrant visa. Actually, what will be issued is a non-immigrant visa. So once the petition is approved, that Form I-129 is sent across to the American Embassy or Consulate in the foreign country. So the American fiancé will now begin the process of applying for that K1 visa. And that would mean having to fill off Form DS-160. It has to fill that form because the form is for non-immigrant visa. Okay, K1 visa is actually non-immigrant, and it's actually for 6 months. And so the American fiancé has to take all the necessary steps, bring all the necessary documents that will be required, and then schedule the appointment with the American consulate or embassy in his or her own, or in his or her home country, as the case may be. And so it is, of course, the embassy officers, visa officers, that will now consider that K1 visa application for a non-immigrant visa, that's the fiancé visa. And of course, they have to see those documents, and the approval from the National Visa Center of the K1 petition that would have been filed by the American citizen would also be part of the documents they want to see at the interview. And so at the interview, the USCIS, through the visa officers, will determine whether the fiancé to the American citizen qualifies for the K1 non-immigrant visa. So if they find that he or she qualifies, then the visa is issued. And that visa is actually for 6 months and single entry. So the K1 non-immigrant visa is usually for 6 months and for single entry, because immediately the foreign fiancé enters into the US, the expectation, because it's a K1 non-immigrant visa, the expectation is that the marriage has to happen within 90 days of the fiancé coming into the US. It has to happen within 90 days. But on the other hand too, because there's also a possibility that there could be a denial of the K1 non-immigrant visa. In other words, the consular officer who interviewed or who interviews the fiancé to the American citizen might also decide that, look, doesn't believe that the relationship is genuine, and as well might go ahead and refuse the K1 visa. And so in that situation, what happens is that form I-120, that form I-129 will now be returned back to the USCIS for keeps in the US. So it has to be returned, and then if the American citizen and the fiancé are also committed, they can also, if they really want, they can make another application. In other words, if that application is denied, the American citizen and the fiancé can also apply for another, they can also make another application. They can also send in another petition, another form I-129, and start the process all over again. But it's actually very tedious, and also it costs some money as well. But however, now, if on the other hand, the fiancé is granted the non-immigrant K1 visa in his or her own country, then he or she now moves to the third stage in the process. And that third stage is inspection at a port of entry. In other words, if the DOS or the US or the embassy, the consulate issues a K1 non-immigrant visa, the foreign fiancé will now begin to travel or come to the United States and will now seek admission at the port of entry. In other words, at any of the international airports. Now, the foreign fiancé will now seek entry into the country on a K1 non-immigrant visa. And so, yes, we'll seek entry at a port of entry while the K1 non-immigrant visa is valid. So that has to happen within that 6 months, and that means that the non-immigrant K1 visa must be valid for the foreign fiancé to be hopeful of gaining entrance into the United States. So as with any other visa, a K1 non-immigrant visa does not guarantee admission to the United States at the port of entry. In other words, if the foreign fiancé comes to the country at the port of entry, now an officer, a border agent or immigration, the border officers will now have to, who are usually at the port of entry, will make the ultimate decision about whether to admit the fiancé or not. So usually at the port of entry, you see the customs and the border patrol agents. So they will have to vet the fiancé. They will have to vet the U.S. citizen's fiancé coming from abroad, even though he has gotten his valid K1 non-immigrant visa. But he or she also has to go through the port of entry, go through all the checks, and if everything is satisfactory, and then they will not let the fiancé in so that he or she can join the American partner and they form a family, and they now begin the process of having their marriage celebrated in the US within 90 days of the fiancé entering into the United States. Very important. Now, stage 4 of the process is the marriage proper. And of course, the K1 visa is solely the permission for the fiancé to come to the US for and on the sole, just for the purpose of getting married to the US citizen. Okay? So the stage 4 of the process is the marriage itself. So if the foreign fiancé is admitted on a K1 non-immigrant visa, now the American citizen and his or her foreign fiancé have 90 days to marry each other. So the American citizen and his or her foreign fiancé will not determine where to do the marriage, either in a court, in a church, or as the case may be. But the law allows them 90 days max to perform the marriage. Because if not, the foreign fiancé will run into some immigration issues and could still be deported if care is not taken. And so after the marriage has been celebrated, now the stage 5 is what is called adjustment of status. And to adjust the status, the U.S. citizen will have to file the necessary forms to the USCIS within the United States to regularize the stay of the fiancé. So there has to be that adjustment of status, which has to be filed by the U.S. citizen using the appropriate forms. So if you marry if that marriage happens within 90 days, now the foreign fiancé and of course the American citizen will then have to apply. There has to be an application for a green card for the foreign fiancé, and that will happen on Form I-485, the adjustment of status. Once the fiancé comes in and the marriage is celebrated and is successful, now the step 5 is the adjustment of status, in which case the American citizen would want the foreign partner, the fiancé, to now be given or granted a green card. And to do so, now the American citizen has to file a Form I-485, which is for the adjustment of status for the fiancé, because the marriage has been done within that 90 days. And so the adjustment of status is now the next level. Okay, so the Form I-485 will then be reviewed, and all the documents required will be submitted, and that Form I-485 can also say we may mail a request for evidence to your spouse if we need additional documentation or information. So the USCIS, once they receive the Form I-485, they might ask for further information. Okay, so some of this information could include that petition, the petition I-129 that actually approved the marriage, the whole processes, the police reports, the immunizations, and every other record, any other document that is required. So those documents will now be forwarded to the USCIS for the adjustment of status. The adjustment of status would mean that the fiancé will now be issued with a green card and of course a social security. Okay, so very, very important. So, but the truth of the matter again is that after the Form I-485 has been filed and documents submitted, now there's also a need for the American citizen and the fiancé to appear for an interview, within the U.S. It says you and your spouse will usually be required to appear for an interview. So the USCIS will then organize an interview. And the purpose of that interview is to really establish that the fiancé and the American citizen, they're actually in a bona fide or bona fide relationship. That relationship has to be proven beyond all reasonable doubt. Okay? So it is one thing to say, okay, you are bringing your spouse or your fiancé. It's another for you to face all through the hurdles. These are requirements from stage 1, 2, 3, 4, and 5. The 5th stage is, of course, the adjustment of status. In other words, you are now helping your fiancé to now be issued with a green card or a social security number. So, like I said in my previous videos, I'm working on building my page. I would encourage you to follow me on TikTok, to follow me on Instagram, to follow me on YouTube, to follow me on all social media network: Instagram, TikTok, Facebook, and YouTube. I would wish to read your comments I would wish to hear from you a feedback. I know I have been bringing out good information, and so I need to know how you guys responded to it. Now, you can also find my contact information on my Facebook page, actually. So feel free to reach out, feel free to call in, feel free to send a DM, and I will respond. Okay? And so now, if you were married for less than 2 years at the time the Form I-485 is approved, USCIS will grant you your spouse conditional permanent resident status and issue a green card valid for 2 years. In other words, if your marriage had actually lasted less than 2 years, let us say within the 90 days on entry into the US, you and your foreign fiancé, you get married. Now you file the petition for adjustment of status using Form I-485. So the information is that the USCIS will only issue a conditional permanent resident status and issue you with a green card that will last just for 2 years. It's a conditional one because your marriage has not lasted longer than 2 years. So the initial approval will be just conditional. And so what that means is that you now will have to stay a few more years before the final and the conditions will not be removed, and you will not be given your complete residential status. You know, you become a full, you have your full resident permit, and of course your green card, and all the conditions are removed. So because if the marriage is less than 2 years, you only get a conditional green card, as the case may be. Okay? So your spouse will need to remove the conditions on his or her residence by filing Form I-751, petition to remove conditions on residence, in the 90 days before his or her green card expires. So let's say you've been issued with a conditional green card or resident status, and then because your marriage has not lasted up to 2 years, now the information is that before that 2-year period expires, you have like towards the end of the period, like 90 days to the expiration date, you now will have to file Form I-751 for removal of all the conditions. Okay, so that, you know what, the whole issue at this point is that there are levels and levels of processes and procedure, and it's quite simple but tedious in itself because all the twists and turns, and the relationship has to be viable, has to be visible for all of these processes to go smoothly. Sometimes when there are issues in the marriage and there's a divorce before the 2 years, and then there has to be a whole lot of other considerations. Now there has to, it then means that the American citizen and the fiancé might have to resort to going to court and all that if the marriage breaks down within a space of time, maybe before all the requirements are met and before the permanent green card or resident status is given. And so in all of this, you know, care must be taken that all the due processes are followed, and all the issues are resolved, and that the processes are followed to the letter. It can be tedious, and it involves finance. It involves the fiancé and American citizen having to work together. And so if you need further information and instructions, and then you can go online and read Green Card for Fiancé, you know, by the American citizen, and so on and so forth. And so I want to thank you all for listening today. It's been a wonderful time. I want you guys, as usual, I plead with you all to follow me on TikTok, on YouTube, on Instagram, and on Facebook. It has been a wonderful time today, and I will come your way again very shortly. Please follow me. Please follow me. I need to read your comments. Please share. Please like. Please comment. Encourage me. Encourage my efforts. Thank you so much for watching. Until I come your way again, God bless you, and bye for now.